Hello, everyone. Welcome back. Today, I'm really excited to showcase the career of judicial career clerks or staff attorneys, depending on which court you're working for. And I have three UC Hastings grads here to tell you all about it. Ann Scott, Sarah Beard, and Jerry Burke. And so I think I'll just start by turning it over to them one by one. They can talk for 5-7 minutes about how they got to where they are, what their jobs are like, and give you some thoughts about all of that. And then we'll turn it over for some questions. So Ann, let's start with you.
Okay, thank you. Thank you so much for having me today. So my trajectory was pretty straight. I don't know if I can fill 3 to 5 or 5 to 7 minutes, but I attended UC Hastings and graduated in 2011. And then during my third year at Hastings, I was an extern for Justice Chin, and I really enjoyed that whole experience, learned a lot. So from that, I realized I was gravitating more towards the research and writing aspect of the law. And so in my third year, I pursued clerkships all over the country, applied to probably 150 or so. And ultimately, I got a few interviews, but ultimately got an interview with the California Supreme Court. And I started there in September of 2011 as an annual on the criminal central staff doing criminal work, and stayed in that role for 8 years. And then in December of 2019, I was hired by Justice Groban to be one of his permanent chambers attorneys. So I presently work for Justice Groban and help draft opinions on his behalf. And I really enjoy that role. And I now get to do civil, criminal, habeas, and just the spectrum of work that way. So that's where I am, and that's a quick story.
That's great. Jerry.
Hi, I'm Jerry. I graduated from Hastings in 2007. When I first graduated, I went to work for a law firm, White & Case, down in Palo Alto. I was there for about 1.5 years. I had applied for clerkships while I was at 3L, and while I was working at White & Case, I got an interview for a clerkship at a federal district court in San Francisco. He was a senior, Judge Conti, he was a senior judge there. He's since retired and passed away. But I clerked for him for 2 years. Then I went to work for a law firm doing civil work in San Francisco for about 4 years. And then I realized, based on a clerkship experience mainly, that research and writing was kind of what I wanted to focus on. So I became a research attorney at Alameda Superior Court, then at the First District Court of Appeal in San Francisco, and now I'm at the California Supreme Court, also on the civil central staff. But I guess in general, what I would say is, there's as a course like this is probably showing all of you, there's many different kinds of attorneys out there, and you really have to kind of figure out what's the right fit, I would say, for your personality. And a research attorney job, I would say, it's a very kind of a monastic job. You're often just kind of working by yourself, either in your office or at home. So you have to be the kind of person who, likes to spend, many hours just by themselves, digging down into a legal issue. But I love that. So it almost doesn't feel like work for me when I'm doing this kind of work. And so I'm happy to answer any questions that you guys have.
Thanks, Jerry. Can you say just a few words about what the different feel is between, working at the Court of Appeal and the other two staff attorney positions you've held?
I would say as a research attorney at the Alameda Superior Court, it's very, the pace of the work is very fast. It's trial court work. So you're normally working as a research attorney on civil law and motion matters. There's a lot of kind of discovery disputes, I would say, when you're working on civil work at the trial court level. At the Court of Appeal level, I think one of the things that's really nice about it is you don't have to deal as much with discovery kind of issues. I felt like those were kind of the bane of my existence when I was in private practice. not so much discovery disputes at a court of appeal level. It's more kind of, you know, you have more time, you can kind of set the schedule a little more, because the justices typically will not put an appeal on their calendar until they already have a kind of a good handle on the issue. It's a bit more abstract. You're writing kind of longer, more in-depth opinions. And I would say at the Supreme Court, it's even kind of a further level of abstraction. I'd say right now I'm part of the Civil Central staff, which is a staff of 16 attorneys. And we're kind of really just focused on whether the Supreme Court should take up a particular issue that was resolved one way or the other at the Court of Appeal. So it gradually gets more abstract, but even at the trial court level, as a research attorney, your primary focus is research. You know, if you like research and writing, I would say it's a great place to start in terms of working your way kind of up the ladder as a research attorney.
Thank you. Sarah.
Hi, everybody. So I am a career law clerk for a United States magistrate judge at the U.S. District Court in Oakland, which is part of the court that Jerry started out with. And I've been in my role for about 11 years. And my path to a clerkship was a little unexpected. I didn't have it on the horizon as a possible career path for myself. When I was at Hastings, I was really interested in public interest work and sort of thought a clerkship doesn't really fit along with that. And I'm here to tell you it absolutely is something that fits in with that. It is definitely public service and it is definitely in the public interest. So I thought it was for people that were going to go work at big law firms. And when I was at Hastings, I did a clinic, the Civil Justice Clinic, and met my now judge, Judge Donna Ryu. She was my professor in the clinic, and she and I tried a case together in the clinic and formed a really good relationship. I left school, practiced plaintiff side employment law for 5 years, and then realized litigation just was not the best fit for me. By that point, she had taken her spot on the bench here in Oakland, and we were still in touch. And I came to work for her to try it out because we knew we worked really well together. And here I am 11 years later. It's a fantastic job. It's really, really satisfying work. It is a completely, at the trial court level though, as Jerry alluded to, it's a completely different pace to the Court of Appeals or the California Supreme Court. Or any other sort of higher level court, because we handle everything soup to nuts, filing of the complaint, challenges to the complaint, and then the life of the case through trial and post-trial work. Discovery disputes are a huge part of what I do. They're also the bane of my existence. Not so much. The job would be pretty miserable if I hated discovery disputes that much, because it is a big chunk of what I do. But it's just fast paced. We're just dealing with, it's not as reactive as the practice of litigation is, but it's definitely still reactive in terms of when emergency things come up or last minute requests. In addition to managing the motion work on my judge's docket, I also have to manage a caseload, which means anything that gets filed in the case, I have to be on top of it and just help manage the caseload on behalf of the judge. But it's really satisfying work. And I realized when I got to this job that legal research and writing was something that was really satisfying to me. But for me, as an extrovert, the process of collaborating and working in close connection with my judge sort of satisfies the need to be around other people and talk to other people. And I have a collaborative relationship with my co-clerk also. So it's a fantastic job, but it's definitely a different pace than the higher court levels are.
Sarah, are there differences between being a career clerk in federal court and, say, a staff attorney in state court?
Yeah, I mean, based on, conversations that I've had with people who have been staff attorneys at state court, Jerry, correct me if I'm wrong, but at state court, you're not attached to one judge. You're sort of in a pool or you're attached to a department. And so you might be working with different judges. At in the federal court system, each judge can have 2 to 3 law clerks, depending on whether or not they're a magistrate judge or a district court judge, Article 3 district court judge. And you are selected by and hired by the judge, and you just work for that judge. So having a strong relationship with the judge that you're working for is sort of the key to success in the role. As I mentioned, my judge and I had worked closely together in law school, so we have a strong relationship. I think probably at state court, maybe you have better relationships with different judges over time, but it's a different relationship. You're more floating than just attached to one specific judge.
Yeah, Jerry, do you want to follow up on that?
Yeah, I would say that's right. I mean, there are, of course, 58 counties in California, and each, county has its own superior court, and each of those probably does things a little differently. But I was at the Alameda County Superior Court, and the way they did it there is for attorneys working on civil work, you were usually attached to a particular judge for their civil law and motion matters, but that wasn't the only thing you did. I also had an assignment, for example, with a criminal judge where I was assisting him with 995 motions, which are sort of like kind of motions to dismiss in criminal cases. And so, and then I was also sometimes going to the San Leandro Juvenile Justice Center to help the presiding justice there with various issues in juvenile court. So I would say one thing about being a research attorney at the California Superior Court level, if you're doing civil stuff, it can be a broad range of stuff. It can be general, businesses suing each other. It can be neighbors suing each other because their trees are blocking their view. It can be, juvenile work, family law matters, probate matters, conservatorships. So it can be a broad range of stuff. And I would say one thing that I really like about being a research attorney in general is that you do have an opportunity to really develop yourself as a generalist in that way. You don't tend to specialize in the same way that you will if you go to work for a law firm. Yeah.
Now, and you work for a single justice on the California Supreme Court, right? Can you say a little bit about how that hiring process works and how it is to work in chambers for a single justice?
Yes, so I had both experiences on the central staff. We served the court as a whole, whereas each judge at the Supreme Court, or each justice, has 5 attorneys that work under him or her, and there tend to be specialties amongst the attorneys, and so my area of expertise would be very strong, but the area in which I'm most acquainted is criminal law. So I focus more on criminal cases that are assigned to Justice Groban. The Chief Justice distributes cases, and I will work with him in drafting opinions for those cases in particular. And it's a very, like I'd say I talk to Justice Groban on the phone with regularity. Like it's a very personal relationship, and the relationship with the judge, much like Sarah was saying, is important and can really affect the dynamics. So it's a nice kind of shift, I'd say, from my central staff experience in that way.
When you're working for a single judge that doesn't have life tenure, what happens if your judge decides to go elsewhere, or what kind of expectations do you have about that, Anne?
Well, you may have seen in the news recently that Justice Cuellar just took a new job, and with his departure, his attorneys are hopeful that whomever is appointed next will absorb them. But it is kind of, when you're attached to a single judge, there is that unpredictability. And usually the court likes to, like if there's openings elsewhere, they'll try to fill them with current attorneys. But it is an aspect of the job that is worth considering. And I know for me, it was nice to know that I'm working for a newer appointee who's a little younger and foresees being at the court for some time. So there is security in that. And
Sarah, how about you?
Yeah, it's something that I'll have to confront at some point. My experience of, I haven't seen that many judges in my district retire or resign. There have been a couple. My understanding is that the judge that, in terms of magistrate judges, because I work for a magistrate judge, when one magistrate judge leaves, the incoming magistrate judge usually either gives strong consideration to hiring the career clerk for the departing judge, or there's some other role that's sort of carved out at the court, or they move on. I mean, it's definitely something to think about. It's not the most awesome thing to think about when you have a really close relationship with the judge that you're working for, but it's not an indefinite situation. You're not guaranteed a position with an incoming judge. You'd have to go through the application process. But the hope is that the incoming judge will look to an experienced clerk to help get them off the ground when they're starting in the position.
What I mean, one great thing about your respective jobs is that you're out to find the right answer. You're not just advocating for a particular position that you might or might not believe in, but you have to because it's for your client. I imagine that must be a very satisfying role that you play, is to try to get it right. But is it also anxiety writing? I mean, do you stay up at night sometimes after you write a memo to your judge thinking, oh, what if I missed something or got it wrong? I'd be curious to hear what your thoughts are on that. And maybe we'll start with Jerry.
I would say I had a lot more sleepless nights when I was in private practice than when working at the Court of Appeal or as a research attorney at the Superior Court. But it is one of the more satisfying aspects of the job, I think, that instead of working in private practice for a particular client, where you're kind of doing everything you can to figure out how can I make it so that my client will prevail, you're trying to figure out the right answer to a dispute, and so you don't feel like a hired gun. I think one of the real benefits of the job is that you do feel like you have a role here to try to come to the outcome that the law requires. And at the end of the day, as a research attorney, you're really just making recommendations to your judge. So at the end of the day, it's the judge's decision. And, most of the time, they'll probably go with what you recommend, but there will be occasions when they will, not want to go a different way. And, that's fine. I've never really had the experience where a judge, kind of held it against me that I made a recommendation that he or she disagreed with. There's often more than one reasonable answer to a lot of these problems, and they often, your judge often wants you to be a devil's advocate, and so I think they really see that the whole process benefits from having a debate with their research attorneys before kind of making an ultimate decision. And just to say a little bit more about like the Court of Appeal process. So I worked at the First District Court of Appeal, and of course in San Francisco, there's 6 appellate districts, and each appellate district is divided up into divisions. So the First Appellate District has 5 divisions, and each of those divisions has 4 justices. Each of those justices has 2 research attorneys. So typically you'll be kind of working one-on-one with one of those justices, but then the justices will also confer amongst themselves before they ultimately issue an opinion. And sometimes there might be a concurring opinion or a dissenting opinion. But they really do rely heavily on their research attorneys they want research attorneys to push back if the research attorney thinks that the judge is kind of heading in the wrong direction. So most judges will encourage that and see it as an important part of the job.
And do you have thoughts about what it's like to try to get to the right answer?
Yes, I would say, like, having been sort of a new hire for Justice Groban, initially working on my first opinion, it is a little daunting to think that this opinion you're drafting controls every court in the state of California. So you certainly want to get the answer correct. But the beauty of the California Supreme Court is they have a front-loading system. So it's unique in that way from several other state Supreme Courts, where opinions are drafted, and then you solicit feedback from the non-authoring justices. And so there's this whole dialogue that occurs prior to oral argument. And throughout that, everyone sort of obviously has the shared goal of getting the answer right. So it's a really nice conversation. And I've learned with that shared goal that any criticism is essentially just feedback, and you want to of course, get to the right answer. So I like that aspect of my job, and the fact that justices with different sort of overarching views can come to a shared decision. And California has more, I want to say, more unanimous decisions than any other state Supreme Court. And I think that's a testament to the front loading.
Sarah, any comments?
So in my experience, the process of trying to get to the right answer is it's collaborative, but it's not one that keeps me up at night, really, because as Jerry said, I'm not the one making the final decision. I can only make my recommendation and stand behind it, and talk things through and try to have solid reasoning behind a position that I'm recommending the judge take. It can be at the trial court level, it can be a little bit, I guess maybe some of the harder cases that we work on are when people are represented by themselves and there has been a wrong committed against them, but they either are having a hard time articulating the wrong and the person who wronged them, or have missed deadlines and statutes of limitations have run. Those are the kinds of cases that just make you feel sad, because that's just a function of our system. If you can't have somebody represent you that's giving you good advice, it's hard to be successful. And then we also, at the trial court level, we have somebody, figuratively speaking, checking our homework. We have the Ninth Circuit that will tell us if the judge got something wrong. So it's a little bit of a different experience. The idea of working for the California Supreme Court and working on that seems much more pressure filled. Although we're seeing people that come before our court, so we're sort of on the ground with people. It's different kinds of stresses and pressures, but the whole process of kind of wrestling a decision to the ground is the expression that my judge uses. Let's wrestle these facts to the ground. That's where the sausage is made, and that's really fun. That's the culmination of the work that you've done to get up to that point. All the research that you've done, all the understanding of the facts that you have under your belt, and then trying to get to the best, most just answer within the confines of what the Ninth Circuit and the Supreme Court tell us we can do.
So just to switch gears for a second, I'm curious about quality of life perspectives on this particular job, and any trade-offs that you think the job presents on quality of life issues. Sarah, can we start with you?
So there's definitely, how do I put this? I work a lot of hours. I don't work as many hours as somebody who works at a big law firm, and the trade-off for me is that the hours that I spend working is for the most part satisfying, gratifying work. I have a family, and I try to get home. I'm home for dinner every night, but I'm spending a lot of nights after my kid goes to bed, logging on and doing more work. It's hard to say. The pandemic has sort of changed things, because I think when we all got sent home, we thought everything would slow down, and for this amount of time, things did slow down, and people were settling cases right and left and weren't filing a ton of new cases. And then for whatever reason, it's like the whole docket exploded, and we had a record year number of filings last year, and we're on track to break that record again this year. So there's an awful lot of work to be done. And if you do it right, if you are thorough, then it takes more than the 40 hours a week that you could have otherwise. But like I said, on the flip side, this work is important to me. And so for now, it's fine. The balance is, okay. Sometimes it's better than other times, and sometimes it's really bad, but it's very up and down, and it depends on what's on the docket and what trials we have coming up. So I think my answer is probably going to be really different from Anne's and Jerry's. I know it's different from Jerry's old position, but it's worth it. I don't mean to sound scary or anything like that, but it's not a 9-to-5 job.
Sarah, can I follow up and just ask, does it depend on the judge?
I think it definitely depends. Yes, it depends on the judge and the extent to, what the expectations are. My judge doesn't expect me to be grinding at all hours of the day, but she expects a certain, quality of work product. And she respects, personal time and wants me to, have time off and things like that. But, with high expectations, you put high expectations on yourself. And so you work a little bit harder. I do know that I worked with a woman one time who her clerkship was 9-to-5 because she would generate a draft, give it to the judge, and the judge would read it and sign off on it. And there was not a lot of back and forth. That's not my experience in any way, shape, or form. And I don't know anybody else in my district that has that sort of situation. So we're a very busy district also. So, you worked in New York, Scott. Your district was probably another one that was sort of overflowing with cases. They aren't all like this. So I guess my advice is find like a job at the District of Kansas if you want like a 9-to-5 job or something like that. No offense to Kansas.
Anne, what about quality of life for you, and what are the trade-offs?
I would say my quality of life is, I have as a point of comparison all my friends that are either in-house or at law firms, and I'd say my quality of life exceeds theirs in terms of work-life balance. And sort of to Sarah's point, as you go up the court system, the pace slows. So the California Supreme Court decides on average 100 cases each year. And of course, there's ebbs and flows to work. Like after a case is argued by the Constitution, it needs to be filed within 90 days or the justices do not get paid. So that's certainly incentive to work harder. So if you're working on an opinion, you need to turn things around under deadlines. But otherwise, it's really a job that requires self-motivation, and you can, if you're efficient, you can get your job done within 9 to 5 hours. If you're not, then it might take longer. But I would say it's a very good work-life balance. And my judge is nice in the sense that he'll email me on the weekend and say, don't reply till Monday. And I think that's unique. I'm not certain most judges have that caveat when they email you on a Saturday, but he's very respectful of boundaries and recognizes everyone has their own lives. So I feel fortunate in that regard.
Jerry?
Yeah, I mean, I would say the work-life balance is one of the big reasons why I became a research attorney. And, at the Court of Appeal, I would say almost all of the research attorneys had been in private practice. And, there's a lot of good reasons to start off in private practice. A lot of people graduating from law school have pretty daunting student loans that they want to put a dent in. And if you can work at a big law firm, that will help kind of pay down your loans a little bit. And that was a motivating reason for me to go into private practice and kind of see if I liked it or not. But the hours can be grueling, and switching to a government job will typically be kind of a more 9-to-5 job, although you won't get paid as much, but the trade-off is that you have your weekends and you get to spend time with your family. So that was a big motivating reason for me. And I would say also for almost all of the research attorneys at the First District Court of Appeal made a switch for similar reasons, because they had little children and they just couldn't work the hours that big law firms will typically demand of you.
Great. Well, I think what I'll do is I'll stop recording